This is Michael Popak, Legal AF. If I were Judge Lewis Kaplan, federal judge, Southern District of New York, I would report Alina Habba to the bar for an ethics investigation based on the new arguments that she just raised to distract from her poor lawyering that led to an $83 million verdict against Donald Trump based on the rape, defamation, and for punitive damages by a Manhattan jury. Now, Alina Habba argues for the first time in 3 years that back 30 years ago, for an 18-month period, Judge Lewis Kaplan was in the same law firm as Roberta Kaplan, no relation, the plaintiff's lawyer. And that 18-month or so overlap when Roberta Kaplan was a young associate and Lewis Kaplan was a partner is somehow unethical that he presided over the case. I mean, I don't even know where to start, but I know where to start on this hot take. Alina Habba's citation in the letter written to Judge Kaplan today, which should be the basis of a bar referral by Judge Kaplan of Alina Habba's poor ethics, is a New York Post article, one source, somebody that commented that 30 years ago they think that Roberta Kaplan overlapped for a short amount of time with Lewis Kaplan before he became a federal judge. He's been on the bench that long, and somehow she was mentored by him. I find that, first of all, I'm almost incredulous about it. Robbie and I are of a similar vintage. Full disclosure, I know plenty of people that work at that same law firm, including those that head certain departments. And I worked at a firm just like that one. And I know sort of the relationships. No matter how brilliant Roberta Kaplan is and was, I doubt that an outgoing, soon-to-be federal judge spent that much time with her where she would be considered a mentor. But more importantly, this is something that Alina Habba knew or should have known when she first started in the case 3 years ago. It takes you 2 keystrokes to figure out that Lewis Kaplan was once a partner at Paul Weiss. It takes you 1 additional keystroke to figure out from Roberta Kaplan's professional resume that she overlapped with him for 1.5 years. That has been a known fact forever. Now, first they went after Sean Crowley, who's the young colleague of Roberta Kaplan, and said, aha, she was a law clerk, a federal law clerk for Lewis Kaplan 10, 12 years ago, and maybe he presided over her wedding. This was all fully disclosed or knew or should have known by Alina Habba, who handled the first E. Jean Carroll case for Donald Trump 3 years ago. And if she had an issue, which would have failed under any ethical analysis, that should have been raised at or about the time 3 years ago when she knew or should have known about Shane Crowley's relationship or professional relationship with Lewis Kaplan. Now, completely grasping at straws, Alina Habba wrote a 3-page letter to the judge and said, you, judge, must tell us, the defense, exactly the nature of your relationship with Roberta Kaplan 30 years ago when she was a young associate and you were an outgoing partner about to hit the federal bench. I can't even get these sentences out. She miscites an ethics rule completely that's completely against her, which I'm going to show you now. Even by its very terms, it's against her. And she claims that because of this long-standing friendship that nobody else has been able to suss out, that even the New York Post's article doesn't recite, this is more of a drive-by relationship between senior outgoing partner and young incoming associate. I had plenty of those in my career at my major New York law firm that I worked for. It wouldn't disqualify a judge. The only way a judge recuses themselves or gets disqualified, even if the firm that they used to be a partner in is now appearing in front of them for a new case, is usually there's a cooling off period of 2 or 3 years to make sure any case that the judge worked on doesn't end up in front of him or her being led by the law firm that they used to work for. That makes sense. A drive-by cup of coffee between Lou Kaplan and Roberta Kaplan when she was an associate 30 years ago, Alina Habba knew or should have known all about that and should have moved to disqualify at or about that time if she had the grounds. Obviously, she didn't have the grounds. Joe Tacopina, B, was co-counsel at that time, the recently departed Joe Tacopina from representing Donald Trump in this case, and he didn't raise the issue. Even if they had raised the issue timely, which of course 3 years late is not timely, it would have fallen completely flat because there's no ethical rule that's been violated. Now they claim that because Lewis Kaplan reprimanded Alina Habba for her poor performance and poor conduct as a bar member in court, telling her that she was very close to ending up in the lockup, being found in contempt for her contumacious, contemptuous conduct in the courtroom, her failure to understand basic evidence code, her failure to understand motions in limine and orders that had already been entered, her failure to properly address the court in a respectful way or honor the jury in that same way. That must be that it's always somebody else's excuse in that world. It must be because he had a cup of coffee with Roberta Kaplan 30 years ago, not because of my poor performance as an attorney, an embarrassing performance, shambling performance as an attorney. Not that. It can't be that. Never. And the letter goes on to say, I'm going to read from it in a minute. I'll try to suppress laughter during it. That's why, Judge Kaplan, you're against my client as well, and you showed animus, and that's grounds for an appeal and a reversal. So tell us now what the New York Post has, in a gossipy and salacious way, listed without any proper corroboration in the New York Post. For those that don't get the local newspapers in New York, the New York Post is yes, it was founded by Alexander Hamilton, but it is at the bottom of the food chain of newspapers in New York. Okay, I'll just leave it at that. It's owned by Rupert Murdoch today. Fill in the blank. It's barely above newspaper supermarket tabloids that you get, at the checkout counter. Apologies to checkout counter tabloids. So let me read from the letter, and then you'll see exactly what I'm talking about. Dear Judge Kaplan, written on her letterhead today. We'll put the picture up on it. This letter is submitted on behalf of President Donald J. Trump. Now remember, the judge already told her, stop calling him President Donald J. Trump. He's Donald John Trump. That's it. He doesn't get the president honorific. As a result of a story published in the New York Post, oh my God, I can't even get this out. Defense counsel learned for the first time of allegations that Your Honor, while a partner at the Paul Weiss firm, it's not even the proper name of the law firm, Alina, had a mentor-type relationship with plaintiff's lead counsel Roberta Kaplan. That's not exactly what the New York Post article says. It's uncorroborated, and I can't even believe that it would be true. And if it is true, it's something they knew or should have known 3 years ago and made a motion at that time. Most concerning, Alina Habba goes on in breathless fashion and high dudgeon, is that the article was brought to the New York Post's attention by an unnamed partner at Paul Weiss. So there is the uncorroborated one-person call, who was aware of the close relationship between you and Miss Kaplan and stated that Lou was like her mentor. The underlying defamation case tried last year and the damages trial completed last week were both litigations in which there were many clashes between Your Honor and defense counsel. Right, because Alina Habba can't find her way out of a paper bag when it comes to trial skills. We believe and will argue on appeal the court was overtly hostile towards defense counsel and President Trump and displayed preferential treatment towards plaintiff's counsel. What preferential treatment? That they won their fair share of properly argued motions, that they were able to work their way through the federal rules of civil procedure and the federal rules of evidence in a way that Alina Habba would only dream of? That's the preferential treatment? That you are out-lawyered, outgunned, out-thought, out-prepared in front of a jury? That preferential treatment? Come on. The letter goes on. Indeed, the ruling's tone and demeanor of the bench raised significant concerns before the New York Post investigative journalism. All right, now I got to suppress a laugh. The New York Post may be a lot of things, but an investigative journalistic outlet, they are not. I can't tell you how much of a gossip rag sheet the New York Post is. Although I've just told you. And that they've unearthed new facts. Right, facts about an overlap in professional relationship that Alina Habba should have determined 3 years ago when she got into the case. And again, I'm going to repeat it one more time. There is no rules of ethics or judicial conduct that would require Lewis Kaplan to recuse himself from the case. And all the things that she's pointing to about the hostility and the animus for the bench, it's because of her own misconduct. I mean, I'm sorry that she's, I don't know, 40 something and has been doing this for 10 or 12 years, Alina Habba, but she didn't know to stand up for the judge. She didn't know to call him Your Honor and not call him Sir. She didn't know how to get evidence documents into evidence properly in front of a jury. She didn't know how to make objections. She didn't know how to control her client, so he didn't mutter and act out in front of the jury and the prospective jury. She didn't know enough to tell him not to walk out during the middle of her opponent's closing argument. Whose fault is that? Lou Kaplan or Alina Habba? So they go on page 2 to say, if Your Honor truly worked with Ms. Kaplan in any capacity, especially if there was a mentor-mentee relationship, that fact should have been disclosed by the parties. Okay, well, I am sure we're going to get a scathing letter from Lewis Kaplan, who's going to say that he did not have a mentor relationship, and that the fact that she has brought this to his attention in this way is also unethical, and that he's going to refer her to the bar. That's what I'm hoping for, folks, when I report on this case next. The issue is particularly concerning, Habba goes on, since plaintiff's other lead counsel, Shane Crowley, served as your law clerk and was previously advised that Your Honor co-officiated her wedding. Again, another fact that was both disclosed to them at the beginning of this case about her being a law clerk, easily discernible by Alina Habba, and if it was an issue, she should have brought it to the judge's attention at the beginning of the case 3 years ago. She then quotes from Canon 3 of the Code of Conduct for Judges, but she mischaracterizes it, misquotes it. Does that surprise anybody? And she underlines and highlights the very thing that defeats her argument. That Code of Conduct says that a judge shall disqualify himself in a proceeding in which the judge's impartiality might be reasonably questioned, including but not limited to instances in which, and now this is the part she highlights, B, the judge served as a lawyer in the matter in controversy. Okay, stop right there. Lou Kaplan, the judge, never served as a lawyer on behalf of E. Jean Carroll in private practice, or a lawyer with whom the judge previously practiced law served during such association as a lawyer concerning the matter. And she highlights that, thinking that's her winner. That is her loser. That says, and I'll put it in plain English, as I like to do on these hot takes, that says that if the judge was with a law firm and an associate with that law firm while he was there, worked on the case, he could be disqualified, or where the judge could be a material witness. Read it again. I'll read it again. Or a lawyer with whom the judge previously practiced law. All right, let's say that's Robbie Kaplan 30 years ago, served during such association, meaning 30 years ago, as a lawyer concerning the matter. Robbie Kaplan didn't represent E. Jean Carroll in the 1990s, 1994, when she overlapped with soon-to-be Judge Lou Kaplan. I mean, now I got to question whether Alina Habba can read. Before I thought, well, maybe she just didn't go and, practice law properly and doesn't understand trial practice. Now I'm thinking she's illiterate. She can't read. And when Lou Kaplan, the judge, gets a hold of this, I'm telling you, there is a very good shot, in my view, that he refers her to the bar. While not every mere friendship, the letter goes on, between a judge and a lawyer warrants disclosure and possible recusal, as the Fifth Circuit recently explained. All right, let me stop right there. Wrong circuit. That's the circuit in Texas and Louisiana. The circuit that is relevant here is the Second Circuit. Anyway, she cites a Fifth Circuit case, gets around to a Second Circuit case about bias, which also doesn't apply, and then ends it with admitting that she doesn't have the facts to attack the ethics of a federal judge, which is another grounds to make a referral to the bar. She says here, without knowing more information or having a specific factual denial by Your Honor, we are unable to flesh out our position. Let me translate that. That means she attacked the federal judge's ethics and that of her opposing counsel, who are bar members, without any relevant information or evidence other than an unsourced, improperly sourced New York Post article. Surely, the letter concludes, this court should provide defense counsel with all the relevant facts. At a minimum, this information could certainly prove relevant to President Trump's forthcoming Rule 59 motion, which will be addressed to the outcome of the case. We thank the court for its prompt attention to this troubling matter. I'm telling you, Alina Habba, get ready, because if I know Luke Kaplan from watching him in action in this case and how he's handled cases for the last 30 years, you're going to get a bar complaint. Now, we'll continue to follow what happens. I am sure we're going to see by tomorrow a letter from E. Jean Carroll's lawyers, and then we're going to get Judge Kaplan's response. And I think it's going to be blistering, right? And Alina Habba better go get an asbestos three-piece suit and be ready for what's coming her way from the federal judge and from Lewis Kaplan's and from Roberta Kaplan's, E. Jean Carroll's letterhead. It's coming. We'll follow it on the MeidasTouch Network, on Legal AF, only on Wednesdays and Saturdays at 8 p.m. Eastern Time on the MeidasTouch 2 million strong YouTube channel, and then on audio podcast platforms of your choice. So until my next hot take, until my next Legal AF, this is Michael Popak reporting.
Hey, Meidas Mighty, love this report? Continue the conversation by following us on Instagram at MeidasTouch to keep up with the most important news of the day. What are you waiting for? Follow us now.